Thank you, Linda, and thank you to the Rothermel Foundation for having me. Thanks to all of you for coming. Our pastor, Anna Straight, asked me, "Are you nervous?" And I said, well, a little bit. And I'm usually not. I speak all the time. But I guess, Jesus himself said in Mark 6:4 that prophets are honored everywhere except in their own hometowns. And it is a little bit disquieting to be, I'm not a prophet, I don't mean to say that, but a little disquieting to be in front of a local audience because, these are ideas I think about and I sort of articulate in front of Senate committees or House committees. That's one thing, or judges or things like this. It's another, the people you live with and break bread with and worship with and know and see around town. So, it's a little disquieting for me on this. And it's also, I'm going to be covering some ground I don't normally speak on. I'll talk about it in a minute. I do want to assure you there's no Rothermel board self-dealing going on here with me being the speaker. The proceeds, both the honorarium and the proceeds from the book sales will all go back either to the foundation or to the church here. Brent Schlockman, who used to be on the Rothermel board, actually asked me to do this not long after we moved here in the summer of 2018. I wasn't sure it was ever going to happen because this was originally scheduled for April 2020, and then something happened in March of 2020, and we had to postpone it. And we've just had it's easier to juggle me than our sort of speakers we have to fly in here. So this is the slot that I wound up with here. I originally was going to talk on overcriminalization with a focus on North Carolina, and I'm going to still talk about that a lot. That was what Brent approached me about. I've done some work, I've done some original research looking at the growth of criminal law here in the state of North Carolina particularly, but in other states as well and nationally. But I'm broadening it a little bit and I'm tying it back to some Judeo-Christian principles. That is sort of the principle of the Rothermel Foundation. We've had people looking at science from the weather to the cosmos. We've had people looking at politics and saying, well, how do religious voters behave in politics and things like that? Or people who've been involved, we had the chaplain for the military. How do we deal with religious institutions with the military and all the military folks we have around here? And how do we deal with the church and state issues and things like this? So, none of these things are the sorts of things I normally talk about or write about. So other than teaching Sunday school classes, if I want to teach something on law and religion, we're looking at freedom of religion or First Amendment issues, but not sort of this interplay of law and religion. And, it's just not what I'm trained to do. I'm trained in economics. I'm trained in law. You don't go to an economics final and say, here's what the Bible says, not if you want to get a good grade. You certainly don't say that to a judge. In the general case, we've got an establishment clause. So, it's not how I'm trained to think and think about policy, although I do hope that Anna's sermons and the learning I get from the Bible and from our church community influence the way I think about these sorts of things. So, I've worked now for this month, it'll be 20 years at the Manhattan Institute, which is a public policy think tank in New York, founded in 1978. And I work mainly in the area of law and economics. As I said, I started out mostly in the field of tort law, civil litigation, which is a private law discipline, suits between people. And I've since expanded some of that into a subset of contractor commercial law, corporate governance, securities regulation, things like that. Also, increasingly public law, overcriminalization, the growth of the criminal law outside its traditional boundaries has been a significant focus of my work. And then, of course, the administrative law, the ordering of the state and how laws and rules and regulations, we'll talk about some today, actually get enacted. And so I wanted to adjust my original overcrim thing once I had this book come out. So, I had the book sort of in the back of my mind. I was thinking about writing the book. It's one reason I thought, I can move from New York to New Bern. I can write a book anywhere, and I really want to live in New Bern, and that's why we came here. But as the thing got closer, I was finishing up my book. It was scheduled for publication in September 2020. As I said, I was scheduled to give this in April 2020. So I was like, well, let me incorporate some of the book on this. I mean, the book was originally based on an article I wrote in the summer edition of the Manhattan Institute City Journal in-house magazine in 2018 called The Four Horsemen of the Regulatory State. The unelected, the Four Horsemen, this sounds very biblical, right? But it's really not. I mean, the Four Horsemen is sort of a riff on what the New Deal people called the four conservative justices that were knocking out parts of the New Deal in the 1930s. They called these justices the Four Horsemen because how could they oppose the Roosevelt administration? So that was where this comes in. The unelected here is just not the elect as in a Presbyterian sense, but more just the people that we don't actually vote for, and how do they create rules that govern us. And so, we've heard a lot of energy around this recently. I mean, there were several big cases that came down to the Supreme Court this summer. The area I work on, the big case was West Virginia v. EPA, which looks at these questions of how do we interpret the law and what does the structural constitution, the allocation of powers among the branches of government look like. And so when we were thinking about how to work on this administrative, we said, well, we want to look at the moral foundations of administrative law. Moral foundations not biblical. We were like, philosophical moral foundations. And so we enlisted my friend and colleague Richard Epstein, who's a bigwig law professor, to write a book which became The Dubious Morality of the Administrative State. And it was sort of a critique and counter to another book that was written by Cass Sunstein and Adrian Vermeule, two other bigwig law professors that said the morality of administrative law. So there's back and forth on this. And then my book was really sort of to synthesize this administrative state regulatory question with the other things I worked on. What about tort law? What about criminal law? What about what state AGs are doing or district attorneys are doing? All these things actually fit together in terms of how our government functions, and they're not as neatly siloed as specialists in the academy often think about. So, the book, the subtitle especially sounds more polemical than the book actually is. When you work on books, they want titles that they think will be sexy, even if it's a nonprofit publisher and they're not going to make money on it. And so, how an unaccountable elite is governing America. I mean, I don't think it's inaccurate, but it's not a polemical book. It's substantially a historical book, and it runs through these areas of law that I'll be touching on some of them today and going into most detail on this criminal law place. It's not as meta-theoretical a book as it would sound either. I mean, some of the critiques are like, well, what, you're not even addressing the theory of judicial review or these sorts of things. Judges aren't elected and they're striking down statutes. And yeah, all these things are true. I really was focused on, here are the actual rules that are governing us, the way we have to respond to various things in the government, both the public law and private law system, and how does that work? And by and large, this is an independent process from our actual elections that we vote on. And so it's oriented around my principal research interests, which are tort law and overcriminalization and the state and local officials' use of civil and criminal power to affect national policy, the use of securities laws to pressure corporate behavior through social activism and things like this. It's historical. It's focused, of course, on American law with its British roots. It's not focused on ancient roots. It's a completely secular book. It's not focused on Judeo-Christian roots. I'm going to try to tie some of that in just a second. And there's not a North Carolina overcriminalization focus in the book, but I'm going to talk a lot about some of those principles here because it's where I've done some original research. So let's, there's the book. And let's go to the Bible and the Ten Commandments, the Torah, what Christians call the Pentateuch, is Greek for 5 books. The Torah roughly translates into instruction or teaching or law, as opposed to the writings, the Ketuvim, or the prophets, the Nevi'im, right? And so significantly, the Torah is a legal text, right? I mean, we have the Ten Commandments and other rules in Exodus. The book of Leviticus is a legal book. Deuteronomy is significantly a book of rules, a book of laws. Here we have various representations of the Ten Commandments on the screen. So we've got Rembrandt. We've got, of course, Cecil B. DeMille, who made a silent version, and then the Charlton Heston version we see every Easter. And then, of course, we've got the Mel Brooks version, The History of the World, where there were 15 commandments and he dropped one, right? But these are the commandments we inherit here. Moses, probably around the rabbinical dating of when he was alive was 1391 to 1271 BC, give or take 100 too. Around then is when Moses was alive, so a long time ago. And of course, he goes to God on Mount Sinai in Exodus 19. And then in Exodus 20, the first 18 verses, are here as abridged, what we receive as the Ten Commandments. And then the people see the thunder and lightning, they tremble with fear and stay at a distance. All the biblical laws and commandments, the Ten Commandments alone are said to have been written with the finger of God. That's Exodus 31:18. And the stone tablets were, of course, placed in the Ark of the Covenant, shown a little bit at the end of Raiders of the Lost Ark. But this is Exodus 25, Deuteronomy 10, where they were placed in the Ark. They're not highly detailed. They're a statement of principles. The details come later. They're held in special accord, and there's no punishment specified with the Ten Commandments. So the Christian New Testament interprets this. We were right around this morning if we were in this church when Anna was preaching about Matthew 5. So Jesus gets a Sermon on the Mount. He says the Beatitudes. He talks about what Anna was talking about this morning, salt of the earth, light of the world. And then he says in verses 17 through 20, do not think that I have come to abolish the law or the prophets. I have not come to abolish them, but to fulfill them. For truly I tell you, until heaven and earth disappear, not the smallest letter, not the least stroke of a pen will by any means disappear from the law until everything is accomplished, and et cetera, and et cetera. And then he goes on and expands on the prohibition against murder in the Ten Commandments, talking about anger against your neighbor, going into sort of the implicit motivations, how we feel inside, not simply the act of murder itself, telling us to quickly settle disputes. Does the same thing with adultery, talks about lust in your heart, as Jimmy Carter would famously say in the presidential campaign in '76, and talks about divorce. Yes, we allow divorce, but these folks that are just tossing their wives aside, they're not really complying with the spirit of this law, right? The spirit of this commandment. So they're committing adultery, and so he also then reformulates the proportionality principle. Exodus 21:23 through 25 articulates something which predates Exodus in the Code of Hammurabi, but if there's a serious injury, you're to take life for life, eye for an eye. It's a proportionality principle. And Jesus flips that on its head and says, I tell you, do not resist an evil person. If anyone slaps you on the right cheek, turn to them the other cheek also. And so he further expands love of neighbor, saying, you've heard it said, love your neighbor, hate your enemy, but I tell you, love your enemies and pray for those who persecute you. So Jesus is taking a broader, more expansive view here and challenging his followers inside to be more intrinsically motivated and he's not repudiating the law, but he's asking his followers to do more, right? But regardless, why is this not going forward now? Okay. There, okay. Regardless, important, foundational for Christianity as well. And then the same thing, the Muslim interpretation as well. The Quran expressly gives a special place to the Ten Commandments. The 6th chapter of the Quran observes, we gave Moses the book, explaining things in detail, and then has 3 verses that are broadly parallel to the Ten Commandments. They're in a slightly different order. They don't have the prohibition of work on the Sabbath. They instead have a commandment to give full measure and weigh with justice. But you could see the clear roots and re-explication. And then the 7th chapter of the Quran expressly tells the story of Moses receiving the tablets, destroying them initially after finding the Israelites worshiping the golden calf. So the terms are literally transcribed or translatable as the 10 words or the 10 sayings, the 10 matters in Exodus 34:28, Deuteronomy 4:13, Deuteronomy 10:4. If you look at these and you count them carefully, they're actually kind of 11, right? When you look at them, and it kind of depends how you count them, right? And the Judaic, the Talmudic interpretation in terms of how they group them is a little different than the Catholic interpretation, the Reformed tradition, which is the Presbyterian tradition here. How do you group the first 2, or do you group 1 and 2 together, or do you group 1 and then have 2 and 3 together? So it's said as 10. These statements are make it look more like 11. I like to sort of think about them dividing as such. I mean, we here always talk about, Jesus reformulates this again in Matthew 22, verses 34 to 40. In that, Jesus hears, dealing with the Sadducees, the Pharisees again. He's asked, what's the greatest commandment in the law? And Jesus says, love the Lord your God with all your heart, with all your soul, with all your mind. This is the first and greatest commandment. And the second is like it, love your neighbor as yourself. And those flow from Deuteronomy and Leviticus. There's parallel quotes that he's extrapolating from there. But if you look at this, right, I mean, the first grouping here is basically loving God. It's honoring God, not worshiping other gods, not having graven images of God, not taking his name in vain, remembering the Sabbath. The Sabbath also, we could go either way. Jesus later says, well, Sabbath is for man, not man for the Sabbath. Sabbath's also about rest, but so it sort of depends, and I'll talk about that in a sec. But then the others are clearly love your neighbor situations. Your father and mother or your wife with adultery. You don't kill, you don't steal. You don't bear false witness, you don't covet, right? And so these roughly parallel various concepts, theism and monotheism, idolatry, blasphemy, rest or worship with Sabbath, right? Again, there's a bit of element of overlap there. And then sort of family and marital sanctity, bodily integrity, and property, perjury, envy. So clear relations with God, and these aren't things that we see in our secular civil law, of course. The Sabbath a little bit more. I mean, labor law, labor relations flows from this. It intersects with this, right? Family relations, there's whole areas of family law. There's not special protections for fathers and mothers. There are for children. There's certainly, there's not many in terms of marital sanctity anymore either. There is in tort law in this state and in some places, but the interpersonal relations, this is really where most of the law is and where the common law felonies lie, killing and stealing, but also adjuncts of that around, assault, rape, bodily integrity things, property, stealing. So is that robbery, larceny, burglary, arson, different principles of this. And then perjury is sort of, part of it's an anti-fraud thing. So we say force and fraud. Fraud, it would be perjury, but also just in court, bearing false witness. It's extrinsic to the process. You need to be able to have reliable testimony. But Jesus also pushing folks to be intrinsic. This flows from here with covetousness. This is what's in your heart. This is what Jesus was pushing on later in the 5th chapter of Matthew. But again, we're going to focus on these personal relations. Oops, how do I go back? Nope. Wrong, sorry. Okay. Sorry about that. The common law crimes you can see here, there were only 9 major felonies in the common law. So what is the common law? The common law is the law before, when we started with the Constitution, we didn't have any statutes, right? There were some pre-existing in the colonies. States started creating themselves. But these common law crimes had been evolving through the courts. They were well understood as crimes in England for centuries. And they're thought of as the common law crimes. And there's a few places where you still have these common law crimes. Basically, all this stuff's been codified in almost every state at this point. But you had 9 major felonies, and they basically fall 4 and 4 into the 2 major categories of bodily integrity and property, sodomy being the exception to that. There's no sodomy laws anymore. They've been declared unconstitutional since Lawrence v. Texas 2003. But murder, manslaughter, rape, mayhem, which is intentional maiming, are sort of the body felonies, and then robbery, which is intersex, burglary a little bit too, and then larceny, arson are the property felonies. And then you have misdemeanors, assault, battery, false imprisonment, perjury, and things like this. Now, the interesting thing here is When I first started looking at this, I was thinking, oh, this is really, really good, and this has come down through the Roman law. But the Roman law really predates some of this. In other words, the Roman law developed before Judea was part of the Roman Empire, or the Roman, the Roman Republican Empire. And so, it's a little trickier. And so there are ancient predicates. I mean, we don't know much about Egyptian law, but we do know there was some form of Egyptian law, dating back to 3,000 years before Christ. So this was, about 1,000 years or so before Abraham, and long before Moses. And then the Code of Hammurabi, was 1750 BC. This was more than 1,000 years before Nebuchadnezzar. So before the exile in Babylon. And the Code of Hammurabi was pretty sophisticated. I mean, it had criminal law, family law, property law, commercial law, and things like this. And then Roman law evolved over time. You can see from its founding as the Roman kingdom. Then in 449, they developed what was called the 12 tables of law, and they specified everything from civil procedure rules, criminal law, commercial law, injury or tort law, property law, family law, estate law. So pretty well developed. And this lasted for more than 1,000 years until the Corpus Juris Civilis adopted by Justinian in 529 AD. Of course, that was after the Western Roman Empire had actually fallen, right, in 476 AD. So by the time this existed until the Western Roman Empire fell, and so the Roman law which really permeates Gaul, Germany, England, that influences what we have today, predates this Justinian code. And so a lot of principles, I don't want to linger on them too much because we've got a lot of things I want to get to, but a lot of modern principles here developed in the Roman law. So let's get specifically to our American system now here, and I think the best way to frame this, to connect the history with the American system is, these religious principles, because these are so common in terms of the first Babylonian dynasty, Roman law predating Judeo-Christian law and Judeo-Christian law, they all intersect to a significant degree, these core principles. And this is what the Romans themselves would call natural law. They had 3 different conceptions of law. The American system, I think, was, however, suffused by various of these principles of mercy and forgiveness. Jesus saying in John 8:7, he who's without sin cast the first stone. When the crowd was thinking of stoning the adulteress, these sorts of principles are embedded. I mean, our criminal law is a big part of our Bill of Rights, the first 10 amendments of the Constitution, and there's a reason for that. So, our protections by jury, the right against self-incrimination, all the due process rights, basically the Fourth Amendment, through the Eighth Amendment, excluding the Seventh Amendment, are and excluding the Third. But these are very, well, the Third's before the Fourth, but these are very important core principles that are suffused through the Enlightenment and the Roman law principles with these American system of representative government, limited powers, separation of powers, federalism, and civil rights. So the central premise here of the book is, this is the I'm just a bill guy. I'll get to that in a second. 2 things. The concept of limited powers has been eroded. And if I can get it to flip over, that unelected, unaccountable actors wield substantial government power over American life. Now, I want to emphasize, the original Constitution, while I think it did a lot of great things, it was clearly flawed as well, right? The franchise was limited, slavery was countenanced in the constitutional structure. It took a civil war to get rid of that. It took a lot longer still to have civil rights, voting rights for women. Originally it was just property owners. The same thing was true if you look at the Roman Empire's evolution and you look at the British system's evolution. There's these similar sorts of things, but we had a lot of bad things in the original Constitution. That said, I mean, it's endured through invasion and civil war and foreign conflict and social transformation, economic depression, et cetera. I mean, there were 4 million people in the first national census in the United States. That's all there were. New York was the largest city. It had 33,000 people. So the largest city in the United States was New York, just a little bigger than New Bern is today. It was a 13-state republic. And so, this thing has endured well, and it has expanded, freedoms and franchise, et cetera. That said, even though it's become more accountable to the people through the expansion of the previously limited franchise, in some ways, the government apparatus has become much less accountable because you have a large, overlapping, and opaque government apparatus that's emerged governing people's lives without clear checks and balances or even electoral control. The central government's powers have been eroded. I mean, that's not surprising. The first budget in the first Congress for the federal government was $639,000. Now, there's been inflation, but in today's dollars, that's $10 million. That was the federal budget, right? We're a lot bigger than that now. The second piece is sort of the change in the way laws are made. So this is the I'm just a bill guy. People who grew up in my generation, my wife's generation, we watched these Saturday morning cartoons. And on ABC, they had Scooby-Doo and the Laugh Olympics, and they had the Super Friends, and they had these promotional Schoolhouse Rock videos, Conjunction Junction, what's your function, and what are you supposed to eat? And then they had these sort of policy legal ones, and the Schoolhouse Rock bill was, I'm just a bill. And he said, I'm just a bill, yes, I'm only a bill, and if they vote for me on Capitol Hill, well, then I'm off to the White House while I wait in the line, et cetera, et cetera. Oh, I hope and pray that it will, but today I'm still just a bill, right? I mean, this is the way we all learn it in grade school, right? And it still happens. I mean, listen, during COVID, we had incredible, large legislation move very quickly. So, I mean, it's not impossible to move things through Congress, and we've had a number of significant bills this year. But a lot of this stuff now is done by the sort of phone and pen governance, or by rulemaking, or by coercive enforcement action, or by litigation, and this is what I start talking about in the book. And so in November 2014, and I'm not trying to just pick on President Obama because people in both parties have done this, but anyway, when President Obama came out with the reform, the Deferred Action for Childhood Arrivals, the immigration reform that had not been able to get through Congress, and he said, okay, well, there's 10 million unauthorized immigrants. Now they're authorized, effectively, was what he was trying to do through executive order. And Saturday Night Live, the late night show, spoofed this. They had the bill being Kenan Thompson, and then another guy, it was chain-smoking Parchment. Bobby Moynihan showed up and he says, I'm an executive order, and I pretty much just happened, and that's it. Right? There's not these checks and balances. There's not bicameralism and presentment. There's not judicial, well, there is judicial review of an executive order, and these things keep going back and forth. And this isn't purely the unelected because the president's elected, unlike some of the administrative agencies, which are indirectly appointed and confirmed. But there's a very different way of making rules than we learn about in Schoolhouse Rock or in grade school. And so, I sort of put them into 4 different buckets or categories. The rule makers, these are the folks that draft the rules. These are the regulatory agencies, the alphabet soup agencies, the SEC, the EPA, the FTC. They're structured not all the same, but this is what I'm talking about. The enforcers, this could be your Department of Justice. It could be the SEC taking an enforcement action. It could be the Department of Health and Human Services taking an enforcement action. It could be criminal. It could be civil. This is where the overcriminalization fits in. It's chapter 5 of the book. It's not the whole of the book, but it's an important piece of it, and it's where I'm going to focus in a minute. And then the litigators, this is our private litigation system. It's a little different because it's just like in Roman law, you had private and public law, this is somebody sues you. And it is private in the sense the government's not behind it, but the government's the enforcer still here as the backstop, right? I mean, nobody's going to say, oh, you sue me. Oh, well, okay. There's no adjudicator. I'm just going to give you the money even though I disagree. No, the government's coming in there. You're taking it to court. There's the threat of the government saying we can take money from you. That's our private litigation system, and it's big in the United States and bigger than other developed countries. And then what I call the new anti-federalists, federalism is a great idiosyncratic feature that was almost accidentally discovered as a part of our system. We don't only divide power horizontally between three branches of government, the legislative, the executive, the judicial. We also divide it vertically. So we have the national government, we have the state governments. And that dispersal of power is designed to prevent abuses. But, what happens if the Attorney General of North Carolina or New York or Texas is trying to determine national policy, or a district attorney from a city can determine national policy? And so this is what I talk about in sort of the last section of the book, because it's not just what happens in Washington, D.C. The rule makers, this is the first basic third of the book, and these are sort of the chapter titles, legislating without Congress, administrating without the executive, judging without the judiciary. This is what is often the focus of administrative law, or when we think about the regulatory state, where a lot of, when the Supreme Court cases are coming up, they're coming up a lot in this area. And, Congress has a tendency to write lots of open-ended rules, and there's multiple reasons for that. Part of it is, they don't have the competence to write very careful rules. Part of it is, it's hard to get things through Congress, so we're going to leave the details up to someone else. We're not going to necessarily have to pay the political price for it, but it also can maybe be tweaked by the regulators over time. There's pros and cons of this, but it's a big operation, right? And so the government first started itemizing its new rules in 1976. Since then, as of the time I wrote my book, there had been over 201,000 new rules added to the Federal Register. So we've gone from 10 commandments, 2 of which were these sort of interpersonal relationships that aren't family or perjury or whatnot, and to over 200,000 rules in the Federal Register over that time. And again, it's true of whoever's in charge. The directionality of where the regulations are bending might change, but Donald Trump comes in and says, we're going to have the most far-reaching regulatory reform in American history. The never-ending growth of red tape in America has come to a sudden screeching and beautiful halt, right? It does that through executive order. There were certainly deregulatory efforts made, but in his first year in office, he still added 61,308 pages to the Federal Register, or his administration did. He didn't write it. Some of those were holdovers, et cetera. It was fewer than it had been since Bill Clinton's days. The last year of the Obama administration had been 95,000 in some pages. But, the point is 60,000, 95,000. This is a lot of pages. There's no way you're going to be able to read all these rules that you're supposed to be complying with if you're an ordinary citizen, right? And nobody's really voting on this. There's been a statute that's presumptively given some authority for rulemaking to the agency, but that's pretty much just it, as the executive order guy on SNL would say. And so, here's John Rapinos. He's now deceased, but for 20 years he was fighting the federal government over his own land. He's a son of Greek immigrants. He had 44 acres of land up in Michigan. He used some sand after he pulled tree stumps out of the land to backfill it. Well, the federal government says it's a wetland. Now, listen, protecting wetlands is something that I think is important, but the point is, in the 1972 Clean Water Act, it wasn't really clear. This wasn't a Wetland Protection Act, and the act specified, it forbade the discharge of a pollutant into navigable waters, the navigable waters being defined as the waters of the United States, including the territorial seas. Now, the problem is the Supreme Court for 100 years had defined that phrase, navigable waters of the United States, to mean navigable in fact, i.e., quote, waters that are, quote, used or are susceptible of being used in their ordinary condition as highways for commerce over which trade and travel are or may be conducted in the customary modes of trade and travel on water. So this isn't your land that occasionally gets wet, right? It's navigable waters that you could take a boat on, right? But the administrative agency goes in a different direction, and the courts have increasingly allowed, if it's vague or ambiguous, the actual rule that the Supreme Court came up with in the case Chevron v. Natural Resources Defense Council, different statutory question, it was over smokestacks, but the rule they came up with is, if it's ambiguous, we'll defer to the agency. What's this done in practice? It's meant that the Waters of the United States rule, flip-flops every time we switch from Democrat to Republican administration. So the statute's not changed by Congress. The interpretation changes every time. So this is the sort of thing. Rapinos, he ultimately kept winning, losing, got a minor piece in this, went up to the Supreme Court twice. Ultimately, the criminal case became a nothing burger. He settled the civil case with the government for $1 million to be done with it after 20 years. So this is the sort of thing that often happens. Now, litigators, I'm sort of skipping over the criminal enforcer stuff because I want to focus on overcrim a little bit before we open up for questions. There's some form of private litigation everywhere. Our system is a bit idiosyncratic. I go through different examples in here. We have, unique to the United States, almost in the developed world, Japan has a similar rule, but it doesn't have the other rules. There's very little litigation in Japan, but we have what's called we don't have any fee shifting. So we have other places have what's called a loser pays. So, you win your lawsuit, you get your fees reimbursed. We don't have that here, which means that you get sued. You spend a lot of money defending yourself. Even when you win, you lose, right? And so that's the basic rule here. And because of that, people who don't have any money, how are they going to sue? Because in other countries, you sue, you get your lawyer's fees paid once you win, and insurance companies will underwrite litigation like they will other risks that are dischargeable. We don't have that. So we have the contingent fee here, which gives the lawyers a cut of the action. And so this sort of developed by accident in the early republic. I go through this history in the book. But then by the late 19th century, you started seeing all these folks, which we commonly call ambulance chasers. Because of legal ethics rules, they didn't do that, but they hired other people to go around hospitals literally and pass out business cards and things like this, trying to drum up litigation for their own benefit. Lawyers without clients, this is things like class actions. This was a change in the procedure federally with no real precedent here or anywhere in the 1960s. It was done under the Rules Enabling Act, which delegated things to a committee of professors and practitioners. And literally a Harvard law professor and a young Columbia law professor on the ferry to Martha's Vineyard came up with this in the car on their typewriter and said, we're going to do this new class action rule. This is literally how it became, and now it's a huge part of litigation. Et cetera, et cetera, et cetera. I don't want to go through all of these. I'm so happy to answer questions about it, but I want to get us to questions. So let's get to this overcriminalization piece, where I've done a lot of research on it. We've been working on this at the Institute since long before I got there. The Institute was founded in 1978. I think it was 81 or 82. We published a book called Regulation by Prosecution by Roberto Carmel, who was a former Securities and Exchange Commissioner. I started looking at this early in my tenure, after Eliot Spitzer was using an obscure law, the Martin Act, which was at the time 80 years old and had barely been touched, and started going after the investment banks, the insurance companies. Some of his investigations had merit, some of them didn't, but he was using this rule and really restructuring lots of national industries. So I started looking at this. I wrote a book chapter on overcriminalization in a 2012 book called One Nation Under Arrest, looking at it in New York. And then I started studying different states, and I actually started here in North Carolina. That's partly because I was from here, but not really. There was a professor at UNC, Jeff Welty, who had started looking at this and started cataloging, and I said, there's a good methodology. So I want to pick up what he's doing, expand it, and then look at it in some other ways and start applying it to other states. which is what we did. And we've done this with a mix of states, and we've had sort of red states, blue states, purple states. North Carolina, I think, is a purple state. Michigan's a purple state. Minnesota's kind of a blue state, bluish. South Carolina is definitely a red state, Oklahoma. So we looked at different states, and we saw, and New York's definitely a blue state. We saw the same phenomenon happening everywhere. And we synthesized this in August 2018, basically right when I was moving here, looking at overcriminalization across the states. And so what do I mean when I say overcriminalization? And this is, because it can commonly be misunderstood. What I'm really talking about is a couple things. First, just the rapid expansion in the number of rules. We were talking about hundreds of thousands of rules from 9 common law felonies. Big, big difference. Involving conduct that's not intuitively wrong. If any of you have seen the movie Legally Blonde, I'm showing my intellectual movie taste here, but it's actually a great movie. Hey, but there's this colloquy in the classroom, and the Reese Witherspoon character, who's the blonde girl at Harvard Law School, is going back and forth. The professor is like, malum pro se versus malum prohibitum. And what is malum prohibitum? It's bad because it's prohibited. It's not intuitively wrong. It's bad because it's prohibited. And she ends up, I'm going to take that one because I want a challenge, right? But the point is, most of these laws are malum prohibitum. They're not intuitively bad conduct. Murder, rape, burglary, robbery, arson, they're intuitively bad conduct, right? And then concurrent with that, the erosion of traditional criminal intent requirements for criminal convictions, which can be specific intent, but it also be recklessness, negligence. But a lot of these, it's a strict liability rule. You violate the non-intuitively wrong rule, you're guilty of the crime for these malum prohibitum crimes. Very big shift in the law from what we once had. What I don't mean by overcriminalization are, your traditional violent and property crimes. It's not really hugely related to the incarceration rate, because about 5 and 6 state prisoners are incarcerated for one of the 8 traditional common law crimes. Now, in the federal system, that's a little different. About half the federal criminals are there for a drug offense. They're not generally small possession offenses in the federal system. There's some people. There was a pardoning effort under Obama with some of these. Under President Trump, there was the First Step Act with some of these. If people may have gotten caught up in this, but generally these are big, sort of like big gang drug dealers in the federal system. But in the state system, 5 of 6 are those 8 traditional common law crimes we talked about before that are in prison. And it's not, I don't really mean things like narcotics that are well understood to be criminal. People can debate drug law. I think it's worthy of debate, but that's not really what I'm studying when I do this. These are pretty well understood to be criminal, and it's just a moral debate or a principled debate on it. So what do I do want to emphasize, though, even though most state prisoners are guilty of something like murder, rape, assault, or have been convicted of such, innocent individuals can and do run afoul of these new crimes. They're generally not white-collar criminals. There's a little, again, in the federal system, they're going to tend to be more white-collar criminals. But in the state system, much less likely to be the case. And you tend to get these sort of small proprietors, people that are running little businesses, and they're doing something wrong, and they just don't know the rule. Sole proprietors, family farmers, people like this. It's disproportionately going to be people with less resources, people of color, people of lower socioeconomic status, people that can't afford lawyers to try to comply with all these rules and regulations, which is one reason why there's a lot of bipartisan. It's one of the things, in the policy space where there's some bipartisan energy around this stuff. Here's an example from Michigan that we looked at. We studied Michigan. This woman was threatened with arrest. She was taking her neighbor's kids to the school bus stop every morning, and the regulator said she was operating an unlicensed daycare in doing so. Now, again, the state has a reason to make sure that daycare facilities are run well, right? But what ends up happening is you put a lot of discretion in the part of these officials, and that discretion can be problematic because officials aren't going to be perfect, neutral people in enforcing these rules. I like this other guy here, Colin Grizzle, Oklahoma. He was prosecuted in 2016. He was serving these infused vodkas with bacon and pickles. And it violated some section of the Oklahoma code. I mean, again, making sure the food is safe and all these sorts of stuff. These food codes have a purpose, but, to prosecute this guy. So these things, do actually happen. We've got some North Carolina examples as well. How do I get this thing going? My thumb's not good on it. Can I do it this way? There, okay. So here are the basic problems with overcriminalization. One is just too many crimes on the books. James Madison wrote about this back in the Federalist Papers. It'll be little avail to the people that the laws are made by men of their own choice. We can elect our officials, but if the laws are so voluminous they can't be read or so incoherent they can't be understood, that doesn't really protect us much. And, we started looking at all the penal codes, and this is just the criminal codes in all these different states. North Carolina is actually in the middle on these in terms of the penal code, and that could be good, it could be bad, because the reality is a lot of these crimes that are created are outside the penal code. So this is only capturing a subset of the crimes. Generally, your drug offenses, your traffic offenses, a lot of your regulatory crimes, certain your crimes that are delegated to regulatory authorities to create are outside the penal code itself. The model penal code has 114. That's more than 9, more than 10, but it's a lot fewer than we see in these. And the volume gets really big. I mean, of all these states we studied, there were between 129,000 and 293,000 words. So all of the criminal codes are, substantially longer than my book. And they're not as easy to read, I don't think. The number of crime creation, they just keep getting created. We were studying here one legislative session in each of these states, which is a 2-year window. On average, 42 new statutory crimes were created over this window we were looking at. Michigan had the most over this window, although North Carolina sort of caught up with them. We'll get that at the end once we looked at the next 2 years. We first did North Carolina at 2014. So these are a lot of new crimes each time. A lot of them are felonies. North Carolina led the way. 49 new felonies over a small 6-year window of time were created in North Carolina. There were 9 common law felonies total. Poorly drafted statutes. So they can be outmoded or poorly drafted. Justice Scalia wrote about this in Sykes v. United States. Ever-increasing volume of laws in general, criminal laws in particular, no surprise that so did the number of imprecise laws. Sometimes they're just duplicative. So North Carolina had a law that criminalized the theft or vandalizing of a portable toilet, which is not an unreasonable law, except that there's already laws against this. There could theoretically be a sentencing enhancement, I guess, if the portable toilets were more important than other things. But you're adding whole new sections of the code to try to generate compliance. Vague laws. In Minnesota, they had a law prohibiting drug and alcohol abuse counselors from imposing any stereotypes of behavior, value, or roles related to human diversity. I understand what they're trying to get at here. They don't want bigoted counselors, but there's just no way to interpret this law with any sort of clear notice or fairness. Some of them are just outmoded, and we can always find these are funny. They're not prosecuted, but they're in the book still. So South Carolina has, under pain of imprisonment, an old law prohibiting unlicensed fortune telling. And I'm not sure how you get a license for fortune telling. It's really bizarre. So, and then you have these confusing codifications as well. Outside the criminal code, as I said, when we looked at this new creation, saying that the criminal code's just a window into this. When you looked at this codification, 90% of the new laws that were being created weren't put in the penal code in Oklahoma. North Carolina actually, only 55% was outside the penal code. So most of ours were getting in there in this period, but still a majority, well, not most were not, 55% were not, but we were relatively less confusing in that way. And so, the word counts in many of these criminal codes we looked at were longer than War and Peace. And that doesn't even count the sort of catch-all provisions that create regulatory rulemaking, not to mention government boards, private licensing bodies, state and local, local ordinances and things like this. So then criminal intent requirements, Oliver Wendell Holmes in the Common Law, 1888, sort of classic of American law. Even a dog knows the difference between being kicked and being stumbled over, right? But we've sort of gotten rid of this in this, at least for these malum prohibitum offenses in our criminal law. So traditionally you had to have a bad act, an actus reus, and then you had to have ill intent, mens rea, a guilty mind. Could be purposeful, knowing, reckless, etc. But now a lot of times you don't have them. So Michigan, we looked at this in a joint study we did with the Mackinac Center up there. More than half of the misdemeanors, more than a quarter of the felonies had no criminal intent provision at all in the new laws, the new crimes they were creating. And state courts were kind of doing this, we thought, backwards. They were interpreting silence in the statute about criminal intent as assuming it was a strict liability crime. They didn't want to invent their own, I get that. But they just assumed, well, the legislature knows how to put this in here if they want to, so they didn't, so we're going to assume it's not there. But it's really flipping the old common law rules on their head, where these are intuitively bad conduct. And then finally, sort of the delegation of these criminal lawmaking authorities to unelected public and even private bodies. Declaration of Independence, governments derive their just powers from consent of the governed. Taxation without representation being sort of the rallying cry and the revolution. But all these statutory catch-all provisions, and they were there in some degree in every state. Some were worse than others. Make vast swaths of rules, regulations, permitting requirements. I fell afoul of one of these summer before last on a alcoholic beverage infraction that I was cited for out on the beach. But this wasn't in the statute book. This was a rule that was created, et cetera. So none of these were voted on by the legislature. And so North Carolina, public health, agriculture, environment, the agency commissioners, the secretaries have independent rulemaking authority that can create criminal liability, as do private licensing boards in medicine, dentistry, and nutrition, by the way. None of them have any criminal intent standard. Oklahoma Pet Breeders Act, we looked at, criminalized the violation of any rule later adopted under the act. And subsequently, there was a 20-page section of rules with more than 43 sections. So again, pet breeders can be shady. There's a reason to regulate all of this stuff. But the legislature never voted on it, right? They just gave, you write any rules, anything you create is a crime. That's how they did it. And so North Carolina criminal law, and then I'll wrap up for questions. Today it deals with a lot of ordinary business practices. When we looked at the criminal code, there's 765 sections, so significantly larger than Virginia and South Carolina. When we're trying to do one of these analyses, okay, state legislature, you may want to take a look at this. You're bigger than your neighbors on this. And that doesn't, of course, count all these things. Like we said, 55% of the new crimes in North Carolina were created outside the penal code. So anything from drug, motor vehicle offenses, regulatory crimes, local ordinances aren't in that tally. And, the interesting thing we looked at is most of these weren't getting utilized. So we looked at the crimes North Carolina was adding. And then we looked over the next 2 years, as they kept adding new crimes, the crimes they just enacted, how many of them are actually leading to new prosecutions. And so the state created on average 34 crimes annually, from 2008 to 2014. We looked at it again a few years later, and there were another 114 crimes over the next 2-year window, so that the rate actually went up. Over half of these were felonies. The interesting thing was among the new crimes created, more than 2/3 of them were never charged in the year we studied, and only 23%. So almost 80% of them only had at the most one charge. So they're creating all these new crimes, they're getting them enacted, they're not being utilized. So You might say, well, what's the problem with that? I mean, no one's going to jail over it, but it does create sort of just a compliance nightmare for anyone trying to do anything in business, in farming, et cetera. And it creates a big risk of selective prosecution. I mean, if you want to go after somebody, you can get them. And, you know, it's easy to say, okay, well, we want to get Al Capone on tax evasion. Okay, I get that. But do we want to really get him on these things? I mean, for him, yes. But there's also most people out there are well-intentioned, innocent people. And if they're doing something that's not intuitively wrong, we want to be able to want to get them because somebody in the government wants to get them. You know, we think it's sort of a problem. So this is a long, you know, I've gone down like 3 big buckets here. I sort of went through the Judeo-Christian foundations here, which I'm saying, you know, they're not directly as applicable, but I think the principles are infused in our sort of traditional law, our traditional defenses, rights to due process in the criminal law, you know, the reasonable doubt standard, the right against self-incrimination, the right to an attorney, all these sorts of protections that we have procedurally in the criminal law. But we've then sort of not only grown our government administrative state and taken it away from this sort of tripartite, checked and balanced structure, we've delegated a lot of this rulemaking authority to officials, including criminal rulemaking authority, and it's very difficult for the ordinary person to comply. So the traditional rule of legality is, well, something's got to be specified as illegal. You can't just have a vague law. And then what kicks in called the rule of lenity, protecting you if it's a vague law. You're not going to go to jail for it because you're not on notice. But how are you on notice when there are 300,000 federal crimes? And that's an estimate, but there are 300,000 federal crimes, 98% of which were never voted on by Congress, right? And so it's almost impossible to figure out how you're going to be able to comply with all of this stuff. So I'm going to wrap up there, and we'll take 5 minutes, right, Linda, for you know, look forward to any questions. I'm happy to talk about anything, including stuff that's far afield from this if it's tangential or related. So I hope that was interesting. Thanks.
Let's see if we can get started, and you've got great questions. I hope we will get to all of them. I will try my best. We will try our best together. He's got the answers. I've got the questions. But we'll just start off and see how many we can get through. Let's start with this question. What reforms do you recommend to address the size, complexity, and expansion rate of the country?
That's an easy one. No, the answer is really hard. I mean, buy the book and read chapter 14, but even that, all that's doing is really sketching out parameters that's really sort of only directional. And you know, I part of what I wanted to do this book for was to show the complexity, because the reality is a lot of people will be very siloed in this. And it's like, oh, well, here's our solution to this. But if they're only focused on one piece of it, something else is going to fill the gap. And that's what we often see happening. So, okay, well, you're going to do a regulatory reform here, but then that's going to lead to an enforcement reform there. So if you make it more onerous to draft rules through the regulatory agencies, you're going to get more guidance letters and informal rulemaking. And that could be worse, because then you don't get judicial review. You don't get what's called notice and comment. So you don't get these rules posted, the ability to comment. Then you get a long, exhaustive record. I mean, I do these comment letters, and I don't do the comment. Sometimes they may listen to me. Other times, like right now, you know, I'll be a plaintiff in the lawsuit. So I'm a plaintiff right now in a lawsuit against the Department of Labor alongside 25 states. And I filed 2 comment letters on their rulemaking on changes to ERISA rules for ESG investing. Sounds blah, 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 blah. But you know, the point being, I said, I don't think this is authorized by the statute. Here's why. I think it's a problem for fiduciary duties. I put it in the comment. The final rule was promulgated, notwithstanding my comment. I'm saying this is harming me as someone who has pension investments that are covered by the statute. Therefore, I have standing, and I'm going to take it to the Supreme Court. Right? So, you know, these things happen. But if you don't have a formal rulemaking process at all, And they just do sort of these comment threat letters, which is what often will happen. And I go through this in chapter 4 of the book, which I didn't even allude to here, which is regulating without rulemaking, right? Then it becomes even trickier to review that. So we've got to be careful with it. I mean, I do think in the area of criminal law that I was focusing on the back part of there are some things that should be done. And there's some things that some states have done. And these are things I argued for very publicly. Principles like a default mens rea. So not doing what these states are doing and say, oh, they know how to write it. So that's, as a matter of textual interpretation, there's some logic to that. Because the legislators do know how to put an intent requirement is. The reality is, particularly at the state legislative level, they don't have these exhaustive staffs like they do in Congress. A lot of the people might not even be lawyers who are drafting them. They may not go through Judiciary Committee. They're probably not thinking about all these criminal intent provisions, et cetera, et cetera. So I don't know that it's the right presumption, but it's a sort of normal statutory interpretive presumption. But there's no reason you can't create a default which says, well, we're going to have a default, at least recklessness standard. And that's what Ohio did and Michigan did. And, we worked with legislators on that. We developed, here are some of the trade-offs you could do. And, of course, then they've got to figure out how to make the politics work with all the different various stakeholders and things like that. Much harder to do at the federal level. We tried this, during the Obama administration, and, it didn't go anywhere. And then the Trump administration did a slightly more limited, with the First Step Act, more limited reform. That didn't incorporate it either. So it's a little trickier to do. But you can put in these default rules. You can also sort of put in rules where rules will sunset without congressional reauthorization, or rules won't have criminal enforceability without congressional reauthorization. There's the sort of ambiguity rule in Chevron. I mean, I do think there are rules that are just simply ambiguous, but why should the courts, say, I mean, on the one hand, you can say, well, the courts are, it's ambiguous, so the courts are going to try to do their best job, and if they can't do it, let the regulators, they have more expertise. But that really comes into play when you're talking about questions of fact, like, what's the best way to regulate X? What's the right number of milliliters of lead in the water, or what have you, right? This is something judges aren't well equipped to answer. The regulatory agencies hire experts who presumptively are better equipped to answer it. But if it's, what is the meaning of the word relevant in the statute? I mean, that's kind of what judges are trained to do, and they punt these questions. So what I argue for, and it's not going to happen because I don't think the courts are going to say this is the rule, and I don't think, at least not anytime soon, and I don't think Congress will act on it, but you could create a presumption of non-enforceability, at least criminally, similar to the rule of lenity, and just say, listen, I mean, if the statute's ambiguous, you can't lock someone in jail for it because that person wasn't on notice that it was a crime to begin with. You could create that sort of rule, but there are intermediate steps you could take too by requiring sort of congressional action on that. The litigation, that's all of these things, it's a big thing. I mean, the litigation's a whole different thing, and litigation's complicated because you have state and you have federal. And so a lot of my first years at Manhattan Institute, we were doing empirical studies, and Illinois had a tort law rule that created lawsuits over the manufactured parts. You could create a class action lawsuit and create a settlement against State Farm on what parts you include with your insurance policy. Massachusetts had the opposite rule as a statute. Implicitly, Illinois' tort law rule was overriding Massachusetts' rule in that state that the legislature had enacted via a class action lawsuit that was a national class action. Now, that you can't do easily anymore now because the Class Action Fairness Act of 2005, which was bipartisan, was passed, and that was something that relied on some of this research. Anyway, I'm going too long, so let's go to another question.
Okay. All right, and I am going to say we've got a lot of questions here, so we may need to go slow, quickly. How does spousal privilege fit into the Ten Commandments?
Yeah, I mean, it's an interesting question. I mean, the perjury rules, I'm saying, the ninth commandment, or some folks would call it the eighth commandment. It depends. Some people, some denominations divide the 10th commandment into two different covet commandments. But the perjury commandment is sort of the testimony commandment, right? And the marital sanctity with adultery thing isn't expressly there, but I think protecting the family and protecting marriage values is just, that principle's that important. And we have the same thing with priest sanctity, by the way. So if I talk to Anna and tell her something awful I did and I want God's forgiveness for it, she can't be compelled to testify. With the caveat that if I tell her I'm getting ready to go kill someone, she could be compelled. But that's the limit. Required. Right. But if I'm confessing something I did, you can't. Right.
Okay. Now we know. Is there any burden on the state to be sure that citizens are made aware of the new laws and crimes?
Yes. And generally, when the ex post facto clause means you can't have retroactive criminal laws. And generally, you've got to have some sort of posting. But again, when there's 60-some thousand pages or 90-some thousand pages per year being added to the federal code, yeah, you're technically on notice. It's sort of like when you do notices in class actions, because what we have here is the opt-out class action. So the lawyer creates the class, you're in the class unless you opt out. And what do? They put it in a newspaper, here's a class action. Maybe you get an email in your spam box, right? But this is the notice. So, yes, you're required to. Does it matter much? Not when there are this many rules, I don't think. It's not, it's better than not. It's better than them having a secret rule. And this state's, the old days, they would actually tape the laws up on the post there for people to see.
Okay, the next question, and I think they're referring to what you've given in this, is all of this, the rules and laws, a bad thing or a buffer from the danger of an authoritarian elected official?
I don't think it's a good buffer. I think the checks and balances, the separation of powers, federalism, are buffers against authoritarianism because they're dispersing power. And anytime you're centralizing power in one locus, it's one of the reasons why, listen, there's a lot of reasons why our politics has gotten so much more divisive, a lot. And it's just one piece of it. But when the Waters of the United States rule, or the smokestack rule, or the airbag rule, I talk about all these in the book, when they flip back and forth, depending on which party's in the White House, that becomes a much higher stakes election than having to go through bicameralism and presentment, et cetera, et cetera, et cetera. And so then it becomes a really high stakes election. And the more you erode some of these checks, now listen, some of the administrative rulemaking processes are checked. The Administrative Procedure Act, judicial review. So it's not a simple answer to that. But I don't think it's a buffer. Now, the caveat of this, some of the new anti-federalism stuff, the litigation stuff, which isn't brought by the government, you could argue it the other way on some of that. In other words, because those are more dispersed, I think they can be very inefficient, and I go through why they can be very inefficient, because you could have 15 juries rule one way, and if the 16th jury comes out and puts a mammoth verdict, they're effectively overriding the other 15. So I don't think it's necessarily the right way to do it, but it's not likely to have the same sort of authoritarian abuse as some of the centralization in rulemaking and enforcement.
Thank you. Okay, what is the driving force behind the growth in unelected officials writing laws?
It's unambiguously connected to just the size and complexity of the government itself, right? If you're going to put out 90,000 pages, listen, you're going to have mammoth law. The laws Congress votes on, they don't read, right? They put the laws together, the Rules Committee puts them together, and then they vote on them, and they're 4,000-page bills, and they vote on them in 48 hours. They're not, now, staffers are reading sections of them, and they're hopefully trusting their staffers, et cetera, but they don't read them all either. But I think the complexity is number one. I think number two is our system is designed to make it hard to change. It's a conservative system in that sense that it's a consensus-based system, right? In the session, at least at this church and in most churches I've been on, you kind of work by consensus usually. You know, if you've got 51-49 votes, something's probably wrong, right? We're designed to work that way because you need a majority of the popularly elected House. You need a majority of the Senate, which has staggered elections by state. Then you need a presidential signature. You need super majorities. I mean, we're designed to make it difficult to change direction, and you know that enables us to plan and live our lives. I mean, the economics hat, you know, I wore for a long time. It's like you can deal with some microeconomic inefficiency if you're in business. If there's some stability, you'll just deal with the rule. But if the rule is going to change back and forth all the time, you know, it's really hard to plan and invest in the future, right? So there's a reason why we make it difficult, but precisely because it's difficult, you know, if you're an activist or an advocate on either side of any of these issues, you know, gosh, that's really hard. Well, we can do it this way, which is why you have the executive order pin and phone stuff, which often gets overturned in court. So a lot of times it's show theater. But there's a lot of small ones that get done that way too, or get done through administrative rulemaking. So, I mean, the cynical thing is they're also trying to dodge accountability because they can write open-ended stuff and they're not going to be held accountable. Oh, we didn't mean it that way. Yeah, but I think it's actually a little more practical than that most of the time.
Okay. Does it seem that over the last couple of decades, the legal system has been losing the concept of accidental death? It seems that manslaughter or negligent homicide is prosecuted in what many used to regard as accidental. How do you see that?
Well, I mean, manslaughter has always sort of been an exception to that. I mean, manslaughter was one of the common law felonies. I mean, there are these sorts of long-standing things. Statutory rape's another example where you don't have to have specific intent. I mean, you don't have to know, okay. I mean, it'd be creepy for somebody like me, right, at my age, but if you're, if you're in a state without what's called a Romeo and Juliet law, okay, well, you're 19 and this is a gal you meet at a bar. You know, the statutory rape law is a strict liability rule too. Yeah, I mean, I think there's probably been a shift. It's more of a shift in prosecutorial discretion. I don't think it's a real shift in legal doctrine. In certain cases, it can become very hard to prosecute a case that would be prosecutable legally, and conversely, in some cases, it can be almost essential for prosecutors because of the way they're elected or what their accountability structures or feedback loop mechanisms are. They have to prosecute that case, even if it's a shaky case, and they'll push it. And if it's a certain type of case, you can get a jury to convict, perhaps, even if it's a more ambiguous situation. But murder and rape are two areas where there's always been, some ability to hold people accountable, for kind of accidental, or in the case of statutory rape, just for doing it, right? You're on notice if the person seems borderline, you're on notice, right? I mean, sort of, right? That's the rule.
Okay. How do we chart the correct course on obtrusive governmental intervention and limit unelected influencers in our society? And there was a second one to this that had something to do with COVID pandemic effect in this. Did it slow the growth or the increase? They're two separate questions. Choose one.
Well, I mean, I think the slow the growth is sort of like I was talking about at the beginning. It's a hard question because it's multifaceted. I mean, I think there are things we can do. COVID worked both ways. I mean, on the one hand, Congress did act very, very quickly. On the other hand, the executive branch also acted, but they were slapped down. They'd been slapped down repeatedly in court. So everything from saying you can't evict your tenants, and they haven't been slapped down yet on the student loan thing. But if they're standing, they will be. I mean, they may or may not be standing. Article 3, you've got to have an actual plaintiff that's been injured. But so there's been some pushback from the courts on this too. I don't know if that's related to COVID per se, as much as just there's different justices now that have different views on these doctrines. I mean, no question COVID dramatically expanded the government in some ways, and what we saw were these sort of emergency powers, and we saw it here in this state, we saw it in most states, that this is a long-term emergency powers. So the state law in North Carolina was pretty clear on this. I mean, in an emergency, the governor can act unilaterally in some situations, but it's really sort of designed for, okay, there's a hurricane bearing down on you, you've got to move fast. It's not for 2 years, you don't have to go to the legislature, or you don't even get a majority of the council of state, which is actually, a check on most of these emergency powers that's written into the statute. But, governors everywhere were sort of getting away with this for years, which is not the way it was meant to be done. So there's been a back and forth on some of that, I'd say.
Okay. How does it work out when government attempts to legislate and enforce morality?
I mean, I think every law has some sort of implicit morality in it. I mean, we think about this sort of like bedroom stuff or like drug wars, or these sort of, these more hot button cases. But, I think there's an implicit moral premise underlying any prohibition or any exemption from a prohibition or any, so I mean, the answer is, I mean, again, I think it kind of depends. I mean, I think in general, we've evolved in this country in a direction of allowing for substantial freedom of individual conscience, as long as there's not, like a John Stuart Mill harm principle harming others. I mean, there are other societies and other cultures that don't follow that. I don't know that it's, I kind of like our system because I've grown up in it, and I kind of don't want people telling me what to do, right? But there is a level of, any time, whether you decide it collectively or decide it authoritatively from a monarch or a dictator, anytime you're telling someone, don't do this or we'll punish you in some fashion, that's a moral principle that you're embracing, right? So, I'm arguing that all of these laws are parallel to the Ten Commandments. Now, we've certainly backed away from certain types of moral prohibitions. The first 4 commandments, we don't touch them. We don't have blasphemy laws or idolatry laws. Other countries, some do. We don't have those here for a reason. And the reason was, from the 1500s to the late 1600s, there were a lot of people killing each other over this sort of stuff, and we just sort of agreed to disagree on it, right? And we think it's not, and there's other sort of Christian fundamental reasons why we wouldn't do that too. So that sort of morality we've backed off of. But other countries do it. I prefer our system, but the thing is, but I think everything's got a morality overlay to it.
Okay. Is there a way to get these solutions without problems removed from the books?
Yes, although I think we should be realistic about how far we'd get with it. But there have been states that we've looked at that there was a state that did an unsession, right? I mean, the governor called a special session of the legislature, but all he was going to sign was the striking of rules or laws or regulations from the book. So all he wanted to do was a special session and an unsession to get rid of things. The problem with that is what you're going to get usually are low-hanging fruit, which don't matter much. Licensing of fortune tellers isn't really important to people in South Carolina. No one's getting caught up in that. So it adds volume, but it doesn't add any real risk. Doing it more comprehensively is a much bigger lift. And there have been some people in this state who've been working on it, and you sort of bring in a lot of experts, and you spend a lot of time, and you go through it, and you try to, and, it's complex. And going through, it took us months, and we had people from top law schools working on this stuff, and we had people working on it. This was the main research thing they were working on. And just to compile this stuff and to figure it out was a major undertaking. Then if you want to actually unpack it and see, well, what's the real rationale behind this? How does this parallel to intersect with, conflict with other parts of this complex body of, War and Peace code? it's a hard undertaking. And the problem is there's not a huge political payoff for fixing it, right? I mean, cutting taxes, that's a payoff. Raising taxes if you want to create a new program, that's a payoff. Creating a new program, especially if you don't have to tax people for it, that's a payoff. These sorts of things you can get a payoff. Regulatory changes where a business is going to get a benefit or an interest group's going to get a benefit, there's a payoff. Not a clear payoff on these, so it's a hard lift to do. Can it be done? Yes, but am I optimistic that we're going to do that? No, not unless we have these sorts of sunset rules or others. So we can bake it into the system, but if we don't, I think it's going to be hard to do.
Okay. Do you see any hope for reversal of the increase in the laws and crimes creation in America?
Hope, yeah. Optimism, no. I mean, yes, there's hope. It also depends what you mean. I mean, I work in the policy space, and it's a lot like thinking economically. Marginal wins can matter a lot. So a marginal improvement could matter a lot. A marginal slowdown could matter a lot, right? I mean, to some degree, getting certain clear principles. I think they're going to keep creating. I mean, at the end of the day, why do these laws get put in there? Somebody comes up, okay, I've got all these public latrines. Somebody stole one of them. They vandalized them. Okay, well, we can't find the people who did it. I can't make the sheriff spend more dollars tracking down your latrine. I'll write you a new law. I mean, this is how these things happen, right? I mean, and it's not ill intention. Latrines shouldn't be pilfered or vandalized, right? So. Do I think there's hope? Yes, but precisely because the interest group politics are diffuse, I think it's hard, right? I mean, the interest group politics, look at the history of like the tariff. This is sort of the classic, political economy, public choice question. Every little industry could get their tariff. Consumers pay a little bit more. And so for decades, for most of the early history of the country, yeah, I mean, it was hard to change this system. I mean, it changed somewhat during the Depression. We created various different structures and systems to negotiate trade. It became much trickier because we had to have these multilateral agreements. The whole thing became more complicated. And then you get other interest groups. You get importers, you get retailers, you get other interest groups that actually have a vested interest, and then you start to move things. It's trickier to see that here. But is there hope? Yeah, there's always hope.
Thank you. Would you consider the growth of PACs and subsequent Supreme Court rulings to have an additional growth and those unelected government actors? Not sure I got that one.
I mean, PACs, just political action committees, they're just ways of sort of aggregating speech, right? Political speech. The Supreme Court has stricken down some of these. Citizens United is one people know about. Buckley v. Vallejo, 1976. I mean, I clerked for the judge who argued Buckley v. Vallejo from the Supreme Court. So I have pretty strong opinions on it. I mean, I do think political speech matters, and as much as I hate ads on TV, it depends. Is the cure worse than the disease? I mean, when they passed the law in the wake of Watergate that was reviewed in Buckley v. Vallejo, they had expenditure limits that the Supreme Court struck down, and the maximum expenditure for a congressional campaign just happened to be a little bit below the minimum amount spent for a successful challenger to incumbent in the prior election. Which was very persuasive to William Brennan and Thurgood Marshall when Judge Winter, then Professor Winter, argued it. Yeah, I mean, I think these things are listen, I mean, the lobbying stuff is going to happen. That's a little different than the PACs. The money's there. The interests are there. I mean, I sort of think Madison kind of got it right in the Federalist Papers where factions go against factions. I'm not sure it's much related to this. I do think as much as the politics is unseemly in terms of campaign contributions and how that can buy access, and of course it can, I don't think having unelected agencies makes it better. I think it makes it easier. I think it's easier. I mean, it's harder for the average citizen to communicate with these complicated agency rules and rulemaking processes. At least on the elections, you can vote, right? Which in the aggregate can make some difference.
Okay, thank you. Here's one that's very specific. If the Martin Law was less well accepted and applied, how was it that Eliot Spitzer was unchallenged in applying it in so many cases?
Oh, well, yeah, I mean, this is a pretty easy one. There's just a huge in terrorem effect when you get a corporate criminal investigation. First of all, the Martin Act is extremely broad. I mean, it hadn't been used, but he discovered, it's really broad. You don't have to show materiality. You don't have to show reliance. It's much, much broader than federal securities laws, and it was created at a time when there weren't federal securities laws, and you had these sort of blue sky laws, and they were really designed to stop boiler rooms, and they just had these sort of open-ended statutes. And there was this sort of the notion, the Attorney General, is going to use this in the extreme egregious cases that we're thinking about, but it wasn't really limited to those. Corporations get terrified of this because it can be a death sentence. I mean, if you remember when Enron collapsed, Arthur Andersen was a big accounting firm. It died. And it died due to a criminal investigation on the Enron accounting. Now, ultimately at the Supreme Court, when it got up to the Supreme Court, a few years later, Arthur Andersen won its case, right? It was thrown out. But the accounting firm was dead. Now, accounting firms are idiosyncratically sensitive to this, but so is a pharmaceutical firm if it could be debarred from Medicare reimbursement. So is a contractor that could be debarred from military contracting. So was a financial institution that could be delisted from exchanges. So I mean, businesses are going to be extremely risk averse when you have these massive collateral consequences. And so one of the things I've written about, I talk about in this chapter 6 of the book, is how do we change this? We want to hold businesses accountable. I mean, we've got to be able to enforce laws against them, but if you're never able to litigate them, you create, and I go through an example of FedEx and UPS in the book because, UPS settled the case, FedEx took it to court, the government ultimately dropped it after a week. They were getting embarrassed, and this was sort of people sending, off-brand drugs through the agency, but they wanted to take all of FedEx's planes and have billions of dollars. UPS settles for $40 million. They put in a monitor, they fire somebody, put in a new person. $40 million is a lot cheaper than $2 billion and losing your planes. But FedEx rolled the dice on this because they thought they could win, but that's going to be a rare situation. So I said it's a Corleone offer. It's an offer you can't refuse, and that's sort of what a lot of these businesses are facing. So that's what they face with Eliot Spitzer. They just the act's so big, the collateral consequences could be so huge. We're going to have to deal with you, which is why the board threw Hank Greenberg out of AIG, and 8 years later, they were busted by credit swap defaults because the part of the business that he oversaw, the new people didn't quite understand. I don't think. That's my position.
Okay. All right. Since most elected officials and lawyers own public stock for dividend income, restricting business growth will enhance their present stock portfolio. Could this be the driving impetus for overlawing?
I don't understand the hypothesis, unfortunately. I mean, if you own stock, you don't want to hurt business growth, I don't think. I mean, I don't understand the hypothesis. I mean, I do think, and I was talking to someone before this, I mean, I do think there's been some tightening of the anti-corruption laws, applying it to Congress, which until the Stock Act was passed, didn't really exist. So the insider trading rules that apply to businesses didn't apply to Congress, which is remarkable because they could dramatically influence stock prices up and down. I just don't see why we wouldn't. I mean, it's tricky if you're talking about private businesses, and some people have very large private businesses, but they're not liquid. You can't liquidate your portfolio and put it in a blind trust in those situations. But if you have publicly traded stocks, I think you just ought to be forced to liquidate it and then just exempt you from capital gains tax. It's like step-up basis. It's like a great windfall if you get elected in one sense, right? So, I mean, why not do that? Why have these conflicted people, in Congress, to me, but, Anyway.
All right. What direction are we headed with our regulations? Going over a cliff or learning to pull back?
I mean, I don't think the regulations are going to go over a cliff, right? I mean, there's other cliffs I worry about. It's not regulation per se. I mean, I do think there's some pullback because the Supreme Court is going to pull back. I mean, that could always change, right? I mean, the Supreme Court, it's controversial. And I don't know that the Supreme Court, ultimately the Supreme Court's only going to enforce the extreme outlier cases. And that's probably right? We don't want the Supreme Court trying to do everything. I mean, talk about something that's high stakes. I mean, Supreme Court confirmations are insane, right? They're insane. And because it's really, really high stakes. You've got a lifetime appointment, and one vote can change the whole rule. And it's insane for a reason, because these are important cases, and one side or the other really, really matters to people. But so I do think that's going to lead to some pullback. But I don't see us going off a cliff on it either. I think this is the sort of thing. It's a slow accretion of this stuff. I worry more about cliffs with things like, our unfunded liabilities for Social Security and Medicare. Not that again, it's going to take a long time, but eventually, you can keep borrowing money until you can't. And what happens when that fiscal reality hits? I mean, you've seen it with other countries. I mean, this country is better equipped than a lot. We can push the ball down the road a lot more easily, but I worry about that more than like the regulatory cliff per se. Maybe I'm missing something though.
Okay, we're actually getting through this. Unlike natural science law, societal law seems to be largely convenient to the situation. Natural science shows no consideration for convenience. Is an inviolate structure possible for societal law?
Say the last part again?
Okay, here we go. I'll let you look at it.
Is an inviolate structure possible for societal law? This is deep for me. It's fascinating. Natural laws are going to be like real natural laws. I don't mean the natural law that philosophers and lawyers talk about. I mean like real natural laws, gravity or, combustion and things like this. I mean, they are inviolate in a way. These societal structures are not. I'm not sure that. Part of why I'm a bit skeptical of a strong form natural law. I mean, I get it at the sort of like high theory level that the Romans had. Yeah, there's certain rules. The Babylonians, the Egyptians, the Jews, the Romans, all kind of independently came up with very parallel sorts of bodies of rules. That tells you something. But situations can change, and then this changed circumstances matter. Edmund Burke always said that the principles depend on the circumstances, and something changes here, it might change the way we think about it there. I don't know what the answers are to that, but things like social media are very different. It's a very different world that my kids are growing up in than I grew up in. I don't know what the right answer is, but it's a very different world. Weapons of mass destruction, obvious example. Very different world. These viruses. We've had viruses. The Black Plague killed a third of the people, right? But the air travel, the speed, these circumstances can change, and so I think our principles and our first principles matter. And this is where sort of your religious postulates can, I think, strengthen my natural skepticism about dogmatism, because we're fallible, we think we understand things until we don't. And there's a lot that we do understand that 100 years ago people, or 200 years ago people knew nothing about, but there's still a lot we don't understand. And society is complex. Natural law, particularly certain parts of it, we figured out a heck of a lot. Societal law, I'm less confident in, right? In the social sciences, I'm less confident in what the right answers are. I don't think it's as obvious because these things do change, and one little variable can change, Family structures have changed dramatically in the last 50, 60 years, right? Lots of things underpin that. What does that mean? How do we, I don't know the answers to those questions. I mean, I do law and economics in part because, I can kind of get the right answer in a lot of the things in terms of if this happens, I think that's what's going to happen. When it comes to like foreign policy and these, they're really hard. I don't know. The answers aren't obvious to me always at all.
Nor to any of us. Could you comment just for a moment on the role of the historical role of English common law versus today?
Yeah, I mean, the English common law is the judge-made law, right? And before Parliament got strong, I mean, there were still judges adjudicating things that, were appointed by the Crown. And this sort of just evolved over time, and it evolved, in some ways parallel to the old Roman law. It is a very different system than you see in continental Europe, which is a civil law system, which is much more directly flowing from the civil codes of Roman law. And it's more spontaneous, and it's, from a legal theoretical standpoint, one is much more ex ante and one's more ex post. In other words, the civil law, the law is written out, and you try to comply with that. The common law, it's like, well, you look at each fact pattern, and you can sort of adjust it a little bit. A lot of thinkers will say, well, the common law kind of had some advantages. But I think there's advantages and disadvantages. And this is sort of the intersection between the administrative rulemaking state and then the sort of litigation state we have, which is more common law-ish, even though our doctrines are often now enshrined. There's still a lot more wiggle room. My torts professor at Yale Law, Guido Calabresi, had a great book on this common law in the age of statutes, right? If we put everything in a statute, where's the room for the old common law? Because when you go to law school, you take property law, torts law, contracts law, it's all common law. And you're reading the cases and trying to figure out the evolution and development of these doctrines in the common law. But that's still, with the exception of Louisiana, which, because it was French, is a code state. I mean, every state is technically a common law state here. And so injury law is much more common law. And it does mean that, it's the legal rules that can be really, really important are much more attenuated from the elections, which is why I think it's important for us to keep those in mind and not just focus on the top-down rulemaking. The sort of bottom-up ex-post rulemaking matters a lot too. And most people specialize in one or the other, and there's actually a lot of interaction effects.
All right, we're coming down to the last real question here. Why is this happening, and what can we do about it? What is the fix?
Well, I mean, part of it is just we've gone from 4 million Americans to 330 million Americans. We've gone from the biggest city in the country being New York City, 33,000, to Little New Bern, which was the biggest city in North Carolina through 1840. But Little New Bern's almost 33,000, and New York City's 8 million, and so it's just a much more complicated world. Our commercial structures. I mean, these phones. I was a kid in school, and we had the first computers, and they had 4K of RAM, and we could write a little go-to loop and crash the computer. I mean, these things are way, way more complicated than the computers I had in law school. And everything's together. I mean, the rate of change is rapid. one theory on this, and my friend Richard Epstein, wrote a book on this in 1995, Simple Rules for a Complex World, and his view is, well, the old tort law, property law, contract law rules are really the best rules, and we ought to mainly do this with the old, simple ex post rules. Maybe, but I do think there is a complexity here that's going to, call for answers, and sometimes, economic development can create enormous progress and gains. It also creates enormous inequalities. And, when you look at the growth of the regulatory state, and I do this in, the first couple chapters of the book, in the late 19th century, the Interstate Commerce Commission was sort of the first real agency, and even it didn't have complex rulemaking like today, but, the railroads were creating massive wealth. Right? Cornelius Vanderbilt went from steamships across from Staten Island and New York and New Jersey to from sailing to steamships. He made a bunch of money on that. And then the railroads, and you had Gould, and you had these railroads creating enormous wealth, and then you had the steel industry, the oil industry, consolidations, but radically driving down prices, not modern antitrust price jacking stuff going on, radically driving down prices, and in some ways increasing standard of living, but dramatically dislocating industries. This is what Joseph Schumpeter, the economist, would call, creative destruction of capitalism. So it creates winners, it creates losers. That creates political interests and constituencies for action. So it's a complicated sorts of situation. Our system is designed to make it really hard, and as a consensus-based system, obviously, when there's a radical dislocation, the Depression's a good example. It's no surprise that, the big administrative state growth happened in the late 1890s, at the end of what was called then the Long Depression, or in the 1930s, the Great Depression, or even the Progressive Era followed the Panic of 1907, and if J.P. Morgan hadn't come in and bailed out the financial system, we might have had a depression then. So, when you have and what have we had recently? We had a terror attack followed concurrent with a dot-com bust, and then we had the financial crisis, and then we had the COVID crisis. When you have these sorts of dislocating things, you're going to go down different directions, and then sometimes it's hard to put the genie back in the bottle. People start relying. You get what in the law you call reliance interests. Stare decisis, letting the decision lie. The number one thing. There's a complicated analysis, and various cases have been overriding other cases recently, so people have followed some of these analyses. But if they're heavy reliance interests, it doesn't matter if even Clarence Thomas, who's the most least likely to respect precedent on the court, if he thinks it doesn't comport with the original meaning of the text, he's not going to say Social Security is unconstitutional and as a judge take it out. Or the Federal Reserve and create a financial panic. So, these things develop and then everyone relies on them and it's hard to undo them, right? So it becomes a creative crises. I hope we can fix some of these things before we hit a crisis, because then it's unpredictable as to what direction it's going to go. Right? That worries me.
Thank you. I think you will join me in giving a big round of applause for Jim.